The legal saga over the Ingram-Moore's illegitimate spa complex may not be over quite yet. I've had a few people ask me in the comments whether this is the end of the road, so to speak, and they have no choice whatever but to comply with this notice and tear down the spa pool. Now, whilst that is what the enforcement notice said, and their appeal against it was unsuccessful in that order stands, and I'll go into a bit more detail in that in a moment, it may not be quite over yet. But it would be a very difficult battle for them to challenge it. The only way for them to challenge it is if within 6 weeks they were to apply for a judicial review of the decision, and that will usually only apply if there is an error of law or an error of procedure, neither of which I will stake my prediction will be successful in this case. Now, first of all, they need permission to go for judicial review. It's not just put the papers in and it goes for the full judicial review. You need to apply for permission, which in itself is quite expensive. You need to set out the grounds in quite some detail as to why you believe there's been an error of law or an error of procedure, and then the court will look at it to see whether or not there is grounds, much like if you remember from the Prince Harry cases that I've talked about, where permission is sought to review a decision. Now, the decision has to be one of public law made by a public body. This is not just you don't like the court outcome that you've got when you've sued somebody and therefore you want a judicial review of that decision. It has to be something of public law, public importance, and a public decision. Then it can go for judicial review. At least you can apply for permission for judicial review. As I say, I will stake my prediction that that would be unsuccessful. But of course, any court looking at any application would make that decision all by themselves, and it will stand or fall on the papers and the law presented. But back to the decision itself, which is, I can't put it on screen because it is subject to copyright, but I can quote bits from it. The decision directs, well, first of all, there were several paragraphs of the original decision, and the requirements of the notice were as follows. Number one was to demolish the detached single-story building. Now, many people have asked, is it the whole thing or is it just a part of it? Even some people I know personally have asked me this question. So the answer is it will be the entire thing. The reason for that is not that I'm a planning specialist, I'm not, but this is relatively straightforward. The application was amended, in part retrospectively, but the application applied to the entirety of the building. So it is not just the subsequent portion. If, in hindsight, it had been a separate application and that refused, the original application and the original permission would have stood. However, it was an amended application to encompass the entire building, and therefore it is, as the wording of this notice goes, to demolish the detached single-story building. So it's the whole of the building. The second requirement under that notice was to remove all the resultant building materials from the land. This being the notice to demolish and then remove everything from the premises. Obviously, they wouldn't want all of this building material left lying around because it wouldn't look good in the area. The third one, which I'll come back to in a moment, read that they had to restore the land to its former condition before the building was constructed. Now, you'll remember, if you follow the news, that this used to be a tennis court. Now, that third and final requirement under the notice is one that has been removed. And there's a reason for that. And there was an argument along those lines. In paragraph 50 of this decision, which is publicly available, I'm just not putting it on screen to avoid copyright infringement, it does read here that there was an onus on the appellant to specify lesser steps in which their view would overcome the objections to the development. Whilst the appeal did not suggest any lesser steps than this third requirement in the notice, it did raise concerns that the restoration of the land to the former condition, i.e. the tennis courts, before the building was constructed, was fairly onerous. They state that it would be unreasonable to be required to reinstate the tennis court, which they say would then be removed to implement the L-shaped building planning permission. So this further suggests that there is a plan to reinstate the planning permission for the L-shaped building. So this does raise a bit of an absurdity. If they are demolishing the entire building only to then reinstate the building planning permission for the L-shaped building, which was originally granted, are they then tearing down the entire building just just to replan and rebuild the L shape. That seems a bit odd to me, but that's how this reads as it is. But regardless, this argument was accepted, and the local authority council raised no objection to the inspector exercising the power to vary the notice by deleting that requirement. But it doesn't affect the purpose of the notice, but therefore they were not required to reinstate the tennis court. So this rather bizarrely does suggest that upon demolition of this building, that there is a plan to re-implement the original planning permission. The wording that gives me that view is where it says that the appellant has not submitted any lesser steps but raises concerns with the third requirement of the notice, the restoration part, which specifies the restoration of the land to its former condition before the building was constructed. This is interpreted by the appellant as a requirement to reinstate the tennis courts. It says interpreted because it wasn't clear, and even the inspector accepted that that requirement could have been clearer, i.e. to reinstate the tennis court. But the appellant goes on as a requirement to reinstate the tennis court, which they say is unreasonable, as this would then be removed to implement the L-shaped building planning permission. So it does suggest that there is a plan, loose plan, idea, argument at the very least to reinstate the original building planning permission after the compliance with this notice as it stands. As I say, that sounds a bit bizarre to me. If I were to guess, I would guess that that will not go ahead because for one, public perception, cost for another, and it all seems a little bit strange to take a building down just to reinstate the original planning permission. Failing that, as I say, they have within 6 weeks to lodge an application for permission for judicial review on the matter, and 3 months, which was the final modification to the original notice. The original notice gave different timeframes for different aspects. Now there is only one time frame, that being 3 months, that being within which to comply with both the demolition and removing all the building materials from the land. The final word by Central Bedfordshire Council was that the next steps are to monitor compliance with the enforcement notice, demolishing the building and removing the materials, and expect the building to be demolished within 3 months, as set out in the inspector's decision. So, as I say, a few ambiguities that might arise. As to the judicial review, that is a possibility, but a very difficult and a very expensive one. And otherwise, they will have to comply with this notice within the 3 months stated in the original enforcement notice. So that hopefully addresses one or two of the questions that did pop up from the previous video, and also seeks to clarify one point which I'm sure I mentioned somewhere, that the site would have to be restored to its original condition, but now having seen the notice, that's obviously not the case. That's the one that has been removed for the reasons that I've set out. So restoring it to its original condition is usually just bare land, if it's bare land that's been built on in the first place. But in this case, there was originally tennis courts there, and so it was interpreted to mean restoring the original tennis courts. But as I say, there's a bit of an oddity as to the reasoning given not to restore the tennis courts, which hints at a possible rebuilding of the L-shaped building that was originally granted. However, that alone, in my view, will have some difficulties with it, because any new application, if there were to be a new application, would foreseeably be quite a bit different than the original application, because the original application relied on the fact that it was being a building for Captain Sir Tom Moore and all of those activities. And while the inspectorate said that they were laudable intentions, there was little evidence behind them. So with that finding, i.e. there's little evidence of the intentions behind the use of the building, that would likely go against any application, even if it were made on exactly the same basis in the first place. But I suspect that it wouldn't be able to be made in the same way that it was in the first place, because the independent trustees of the foundation, the Captain Tom Foundation, have said that it was not with their permission that Captain Tom's name was used in that application. So in my view, far too many complexities here for another application for planning to succeed. There's very little scope, really, without diving right into the law. There's no obvious error of law or procedure here, and so I think a judicial review would probably be refused. But as I say, the courts come to their decisions on their own. But I hope you found my views on that interesting, answered one or two questions. Please do bot the like button, subscribe, and watch one of these two videos here, which will help the algorithm and help to spread my channel widely. Thank you for watching.